Annette Dixon-Brown against Holland, Secretary of the Department of the Interior. My friends and followers, this is another one of these disability discrimination cases, failure to accommodate against the federal government, in which we secured a settlement of close to $200,000 on a failure to accommodate a disability. It was in federal court. The plaintiff, a dear woman, Annette Dixon-Brown, a now former employee of the National Park Service. She had a permanent disability, suffering from osteoarthritis in her left hip, right knee, lower back. She could not walk without the assistance of two canes or a walker. And guess what she did? She requested telework several days per week and was denied. Now, in many of these cases, as we all know, the evidence of discrimination, retaliation, or failure to grant an accommodation is circumstantial at best. In this case, however, there were literally emails and testimony from labor relations people showing that her management did not act in good faith when they denied her the reasonable accommodation. And they did it for no legitimate reason. The bottom line here is the plaintiff, Ms. Dixon-Brown, had a computer-based desk job, was disabled, asked for telework for a mere 2 days a week, and the agency denied her request and gave no reason it could not grant it. We deposed a number of witnesses, and we got the information out at deposition that was critical in securing a settlement, and it was a result, I believe, of moving for summary judgment ourselves. And remember, summary judgment is where there's no issue of fact that's material, that basically the parties agree these were the facts, and because of that, the case should break a certain way. The defendant usually brings these in almost every single employment case. Certainly the government brings them. And who says, as I said before, who says you can't bring it? We bring them if I think they can win. The first witness we deposed was a Stephen Schubart, an agency labor relations specialist who worked with the plaintiff's management chain. And there was testimony that she could have done her job remotely 4 days a week. He had a law degree, this guy, which is really, really good, because not only that, he also took a disabilities class in law school. So his testimony mattered a lot. And there's another thing that a lot of times when you ask questions at these depositions and the agency objects, well, this person's not a lawyer. That's a legal question. You can't ask our agency witness this. No, here the guy was able to answer the questions based on his experience and knowledge of the law. And he was a very, very helpful witness. Another witness, David Davies, held the title of Chief of Labor Relations starting in 2014. He described Ms. Dixon-Brown's job in detail, and his role placed him in a position to provide advice and assistance regarding the accommodation requests and to supervise the employee relations specialists involved in drafting responses to such requests. And he described her tasks involving tracking all property assigned to organizational units and individuals within the National Park Service. And the management of this inventory was electronic. It was not physical inspection of the inventory. And this was critical because that demonstrated, and if you think about it, if it's all inventory management by computer, why in the world would you have to be there any of the days of the week? But that question was academic because that wasn't her accommodation request. Davies supervised management chain individual by the name of Garnett Hall, and he provided advice regarding her request. He had recounted at his deposition that he had supported her request. And this analysis led to discussions among the witnesses of Davies, Schubart, Garnett Hall, all of whom were favorable. There was only one bad guy in this case, and that was the person who turned it down, who turned down the reasonable accommodation request, an individual by the name of Shane Compton. And we had emails, the deadly emails in this case, which really do in the agency. A lot of times, I mean, this is why you need lawyers for these things, because the discovery demands, where you try to get every document that's connected to this case that the government has, anything at all, you then need law clerks to sift through these documents, which could be hundreds, thousands of pages, to find the diamonds in the rough here. And we've got one right here. We've got an email, August 24th, 2017. And Mr. Schubart says, for the record, he thinks Mr. Compton is purposely delaying the reasonable accommodation request under the ADA Rehabilitation Act without cause for doing so. And he goes through in the email, you could see the history of how this request was made, why it isn't granted. It's a mystery. And he says right here in black and white, I believe Shane's actions are both unethical and a violation of our obligations under the law, and perhaps may constitute retaliation against an employee for filing an EEO complaint. Well, you didn't even need that. Maybe it was retaliation, maybe it wasn't. At the end of the day, if there's a reasonable accommodation and it can be granted and it's not granted, that's case. That wins. That could win on summary judgment. We had this case in front of Chief Judge Boasberg in the United States District Court for the District of Columbia. Judge Boasberg is a very tough, straight-to-the-point man. And he basically looked at this case. I remember going to the initial conference of this case. I felt very strong about it. This was even without the emails. And fortunately, on a summary judgment motion that we made, we forced the government into settlement here. My friends, this is going to become a very, very big issue in the next few years, which is one of the reasons we're doing a podcast about it. Everyone knows that with the DOGE, that's coming. And Vivek Ramaswamy and Elon Musk, and they're going to be under the direction of the president-elect to go ahead and to make the government more efficient and remove waste and fraud and abuse. And those are laudable goals. Those are okay. That's all right. I mean, I don't think in America opposes that per se. But one of the things that they're delving into is they make it clear they do not like the federal workforce teleworking. They don't believe in it. These are corporate guys. They want to, quote, see what you're doing. They want you there. And there's a radical idea that if you forced all of the federal workers to eliminate telework, you would wipe out about 25% of federal workers. And a lot of them would retire, they'd move on to other jobs, and this notion that they don't really do anything anyway, and it's all nonsense. I mean, some of them do nothing, that's true. Some of them are actually underpaid. And some of them work a lot harder than others and don't make the money they'd be making in the private sector. If a federal employee or any employee is disabled, like Miss Dixon-Brown, and cannot get to work, and has to telework, and needs a reasonable accommodation, unless there's some undue hardship or undue burden to the government, under the law, under the ADA, under the Rehabilitation Act, which applies to federal employees, that person is entitled by law, it's their right, to telework. Doesn't matter what the efficiency thing says. It's got to be an undue burden. It's got to be something like the job here was actually to physically inspect the property. And Miss Dixon-Brown had to do that, which ironically she could have done anyway because she didn't ask for full-time telework. But just the concept of we don't like this you have to come into work every day under the ADA and the Rehabilitation Act, that loses. So, if you are disabled, you have a disability that requires a reasonable accommodation, telework part of the time, most of the time, all of the time, or some other reasonable accommodation that you need, and you are being denied that reasonable accommodation, and you're a federal employee or not a federal employee for that matter, contact our office. We can help. This is what we do.